SJC-12402, Kyle V. Myrick v. Massachusetts Appeals Court.
Thank you. Mr. Myrick, good afternoon. You've got 10 minutes, sir.
Good afternoon. Today's hearing owes itself to an academic employment dispute, which more recently has engaged appeals court judicial posture that Petitioner Myrick alleged had effectively deprived him of emergent causes of action argued as constructible through guaranteed civil parallel under Part 1, Article 11 of the Massachusetts Constitution.
You can raise that microphone if you wish, Mr. Myrick, so you don't have to.
Okay. I have some rather finer, so I'm closer to it than I would normally. Part 1, Article 11 of the Massachusetts Constitution specifying an open court state. Notably, petitioner's side arrives here uncontested, as neither the instant respondent nor an interested lower trial defendant has submitted their briefs. It is plain that the petitioner's MRCP Rule 60B saving clause Suffolk independent action sequence, disclosing, if only by caption, the obligatory hiring, advancement, expertise, and civil indemnifying capacity innate to the individuated, globally visible executive trial defendant is by itself justiciably informative, portending at least conceivable modifications to the dispositive run-up whose obstruction questions Myrick posited should continue to mediate a challenged rescript from Appeal 2015 P466, now underlying. At a minimum, the affecting Suffolk dockets should not have suffered, as they had, by the claimed absence of a captioned actor as operative defendant, insofar as that court had evinced its own awareness that its civil summons for the captioned personified defendant chief should at once be directed to the institutionally equivalent indemnifying office, which depersonalizes that very defendant on behalf of the office or its sued underlings. And Suffolk's awareness in its practices was formed by custom as well as in especial, as the sent complaint's first page had lucidly placed the actor most immediately transgressing as being an agent under the office. It is also discerned sufficient here to illuminate, firstly, the experiential makeup of the respondent court and of a defendant-trained former lead defense counsel who together themselves, through and through, are terminally degreed and so cognizant of the academe. And secondly, the holding within the underlying 466, discrediting the defendant's persistent material diminution of work assignment duration and status. As the first consideration enforces for Dr. Myrick's station and career stage the universally accepted mutuality of hiring and advancement, and the second, the recognition of sustained full employment, the instant respondent had been bound to assign, in aid of the Superior Department entertaining all the plaintiff recommended causes of action, one or even two curative limitations periods, to the advancement failure, grievance, and to the claim of false, albeit non-defamatory, administrative and civil pleadings, so not insulated by the immunized defamation theory that serves as the litigation privilege. And further, the attendant time limits could be drawn from the interplay of chapters 151B and 268 provisions, at points civilly analogized via the invoked Article 11. As a functional matter, these ascertainments are informed by the admissibility of hiring loss data following a non-tenure-related laboratory-specific termination, by the timescale proximities of the appellate to the superior dockets or of the superior to the administrative cases, and by the expectation that the civil session must be regularly opened to a complainant worker's corroborative disclosures from self-discovery, where, to be so, the session must not be laden with no endpoint defensive arguments pleading the, quote, unadministrativeness, unquote, of any and all pertinent civil observations. In this connection, for his administrative phase, the petitioner complainant had already cited advancement blockade animus, and the reviewing civil docket, NOCV 2014-152, then saw electronically memorialized job application failures, which, thus shown to be dated, and which, mindful of their target professional grade, could reasonably be accepted as timely instantiating the career progression adversity. Whereas the aforestated defensive ploy, taken to its iterative extreme, would extirpate the civil discovery stage elemental to Chapter 151B affairs. Respondent Appeals Court, consequently, must equitably recall its rescript in 466, productively reintroduce the job rejection evidence as adverse events, and attach curative limitations periods to them and to the trial defendant's intrinsically material work assignment misrepresentations. The appellate courts was certain had recurred in counties of incidents and residence at more than one or two administrative and court levels. Said rescript recall forces reversal of the subject single justice denial in SJ 2017-137 and actuates the organized opening of judgments in the course of justice run-ups as to petitioners' interconnecting causes of action. This organized endeavor will understandably entail steadfast cooperation among the participant venues and litigants. Whereas the instant respondent's experiential composition and the conventions of limitations period issuance ought to have automatically compelled favorable dispositive action on pivotal requests from petitioner as appellant in 466, and the subject imperative remedies under such automaticity would be unimpacted by any objection from an interested but long silent defendant. The current petition of the uncontested Myrick must be allowed, respecting in all coordinately the instant docket's starting nature, the deliberative priorities accorded Rule 60B disclosures in superintendent actions, and the state constitutional right under Part 1, Article 11, for persons to enjoy civil analogy to the causes of action. The court is now kindly thanked for its time and attention.
All right, if there are no questions, we thank you, sir. We shall adjourn.